Now, the second type of trust are the self-funded special needs trusts, or as we also call them, the payback trust. They're funded with monies of the disabled beneficiary. 1993 was the start date. Here are the standards, and this, for the self-funded trust, the law is very clear. It's kind of cookbook-like, and you can't deviate from it. It has to be for a disabled beneficiary, just one. You can't do it for multiple disabled beneficiaries. Families that have more than one kid with disabilities, or just more than one kid and want one disabled child to also benefit from it, you can create a third-party funded trust for multiple people. Self-funded, just one. It has to be created by a parent, grandparent, guardian, or the court. So the disabled person can't sign his or her own trust. It can't be created by a spouse, an aunt, an uncle, a brother, a sister. The person who creates it, and when I say create it, all I have to do is sign it. There's no good reason for this, by the way. But when Congress created it in 1993, that's how they wrote it. A number of disability groups, after this was passed, tried to do some reverse engineering to find out, really more for curiosity's sake, how did this get in the law? What does it matter who signs the trust, the parent, grandparent, guardian? Who cares if it's the disabled person's own money? I mean, really, why does that make any sense? And I'll answer that. It makes no sense to require that. And they went around to all the committee members, everybody who was involved in the drafting, and no one would own up to it. And I mean, they did some real intensive investigation, and no one could find out who was responsible for slipping that in. But we're now 15 years into it, and we still got it. And so we have to find, I tell a story, we once had to track down a mother of somebody who lived in the bayou of North Carolina, like in the middle of a swamp, to get her to sign the trust. She hadn't talked to her son in 5 years, and we actually got them together to get her to sign the trust for him. So maybe Congress did it as part of, some sort of a family unification program. But we have to do that. In a worst case scenario, you can go to the court and ask the court to approve the trust. So, you may be thinking, what if you don't have parent, grandparent, or the person hasn't been adjudicated, incapacitated, and there's a guardian? Then you can approach the court and ask the court to do that. We have a question from the audience.
Earlier, slide ago, you said that the special needs trust cannot pay cash to the beneficiary.
Right. The question is, the comment was that I said that special needs trust can't pay cash. Right.
Okay. But one slide back, it says the trustee has total absolute non-taxable effect to pay or refuse to pay income or principal from the trust to the disabled beneficiary. Mm-hmm. Well, income or principal sounds like tax to me.
Well,
what am I missing?
That would be better if, make that 2, get your pen and make that 4, all right? So that there's no question about it. To pay income or principal from the trust for the disabled beneficiary. They don't pay the money to the disabled beneficiary. They pay it for them on behalf of you. Don't give cash. So to eliminate any confusion, make that 2 a 4, F-O-R, because you don't pay cash. The bottom line is you don't pay cash from special needs trust to the disabled beneficiary. You can actually give them $20 a month, and that's not a problem. But you buy things for them, and that's how you work it. And you can use income or principal of the trust. Income of the trust is money that the trust generates through investments, and you use it on behalf of the disabled person. You don't make cash payments. Okay. The self-funded special needs trust has a payback to the state for medical assistance in a beneficiary's lifetime. The trustee, again, has to have that total discretion to pay all, some, or none, and that trust must be irrevocable. Pooled trust, we mentioned how it's done by a nonprofit fiduciary using a master trust agreement. Anyone can create a pooled trust, including the disabled person. They can put their own money into the pooled trust, and you don't need a parent, grandparent, or guardian. The residue remains in the trust for other persons with disabilities, and Pennsylvania now requires up to 50% of the residue to be available for medical assistance payback under what's known as Act 42. Leslie Mahalik of our office is going to now talk some on fixing broken trusts and the rapid spend down.
Hi, everybody. Leslie Mahalik. I'm just going to touch on fixing broken trusts real briefly so that we can move on to the other bulk of our program tonight. But in general, I will say that we spend a good amount of our practice actually correcting special needs trusts that were not prepared correctly initially. And it's a really good reminder of how important it is to be sure that this is set up correctly to begin with. It's much easier if it's done right from the beginning. Okay, I'm also going to briefly talk to you about the rapid spend down, which is just another option for when a disabled person gets a sum of money themselves, either from a smaller personal injury settlement or a smaller inheritance where, again, no special needs trust was set up in the wills and in the plan. What the rapid spend down is it's actually not a trust at all, but instead the Social Security Administration and also the Department of Public Welfare allow a disabled person who receives money to spend that money on items for full fair market value within the calendar month that they receive it. It's very important to note that it is actually within the calendar month of receipt, not within a 30-day period. So if you're in a situation where you're trying to plan this, you'd want to have the person get the money at the beginning of the month. But again, they just need to spend the money on items for full fair market value. No gifts can be made with it, either in cash or gifts of items. But there are many examples of things that they could do. They could buy pretty much any resources that DPW and the Social Security Administration would let you have anyway, including furniture, reasonable vacation. They can prepay things like insurance. They can buy a car and prepay the car insurance. Also, they can repay bona fide and documented debts. So it is a really good tool, but again, no gifts, no cash, and they can't buy things like liquid assets such as stocks or CDs that would disqualify them anyway. Okay, and I'm just also going to briefly mention payments for in-kind support and maintenance. I think Dennis touched on this briefly, but essentially when a person who is receiving public benefits, the SSI and medical assistance that we're talking about tonight, when they receive money for food and shelter, those are considered in-kind support and maintenance, and the theory being that your public benefits, your SSI, are supposed to pay for those things. Also, if shelter is provided for the person, if they're living rent-free in their parents' house or something like that, that's also considered in-kind support and maintenance. When a trust makes those types of payments, they must be reported to the Social Security Administration, and then a formula is applied, and it will potentially lower the person's SSI check. Nonetheless, despite the fact that it will be lowered, it's often still something that can be done with careful planning because, in general, the SSA applies a rule called the presumed maximum value rule, which basically states that the SSI will only be limited by about 1/3 of the maximum value that the maximum SSI check that person could receive. So for an unmarried individual, the person would receive about $630. So if in-kind support and maintenance is provided, their SSI would be lowered by about $200, no matter how much in-kind support and maintenance they received. So they could still have their monthly rent of $1,000 paid each month and only have their SSI check reduced by that amount. Do I have any questions on that? Okay, and I'm actually going to turn it back to Dennis.